Nice to see everybody. I hope you're staying warm. It's a balmy, like 34 out there today. It's like springtime, right? Springtime in New Jersey. For those of you in Florida, we envy you. Thanks for attending, but we wish you were there. We were there with you. Oh, Greg Bender's here. Hey, Greg. Nice to see you. So it's good to see everybody. Happy Friday. Let's roll right into it. Is everybody in there, Crystal? It looks like we're good.
Yep.
Yeah. Okay. So what are we talking about? We're talking about snow days. What happened to our gosh darn budget, right? Everyone said it doesn't snow in New Jersey anymore, so we're not going to worry about it, right? Because it hasn't snowed here for real in what, 3 or 4 years. I think people forgot how to remove snow. Um, and then we get zapped with not only piles and piles of snow, but crazy um, runoff water from downspouts and ice and refreezing and salt shortages. And oh my gosh, we can't find salt, table salt, any kind of salt, we'll take it. So it's been a crazy couple weeks, right? But before we get there, I have to do my Fran McGovern official announcements that this is for educational purposes only. No attorney-client relationship is formed by this. If you need attorney advice, give us a call and we will do a retainer agreement and we'll be happy to help you. And none of this constitutes legal advice though today, and none of it will be confidential. So don't tell us about the slip and falls that happened on your parking lot over the weekend, and the where the skeletons are buried, etc. Right? Because it's all being recorded, and we all will hear your secrets. So we have dogs of the day out there somewhere. Crystal, dogs of the day. These are awesome dogs right there. Look at them. Oh my gosh, they're like little living teddy bears, right? So these the dogs are Ozzy and Bowie, kind of semi puppies. Uh, they belong to Ray Barton, who is a property manager and also I think he's the website administrator over there, Association Advisors. Hi Ray, if you're on with us. And they belong to Ray's daughter. They are called, look, this is how fancy they are. They are called cowboy corgis, which apparently is a combination of a Pembroke corgi, or we could say a Pembroke corgi, and a miniature Australian herder. It's like Mr. Howell. Thurston Howell the third would have those two dogs, right? I wonder what they cost. I won't even ask Ray what they cost, but they're really nice dogs, very fancy. I wouldn't mind having one myself. So thanks, Ray. Very nice dogs. Um, let's jump right into snow removal. I shouldn't say snow removal, snow mitigation, snow plowing, etc. So we'll talk first about thank you, right? There is nothing illegal, and this is coming from a lawyer, there's nothing illegal about saying thank you to your board members, to your property managers, and to your snow plow vendors, right? Since COVID, it seems that all people can do is complain, right? We all hate everybody, and it's just complaining, and everything is awful. And why are you here, right? And that's not the case, actually, right? 95% of the people that live in your communities love living there. They're well maintained and well managed, and people have wonderful lifestyles. And sometimes we get sucked down the rabbit hole by the 5% that are miserable. And regardless of where they lived, even if it was Florida, it was warm and sunny, they would still be miserable, right? So don't let the miserable people suck you down the rabbit hole. And keep in mind that the people who are working for you, whether it's the board members, the managers, or the snow removal vendors, uh, are for the most part and largely good people working really hard to do the best that they can in any given situation, right? So it's good to say thank you. So thank you to all of you out there who were awake, doing this. So we have some board members who are snow captains. They're the ones who make the call at 4 o'clock in the morning. They're the ones who call them back out. There's the guys and ladies who sleep in the plow trucks, in the parking lots on the side of the road. They're peeing in empty water bottles. Which I don't like seeing those bottles chucked out on the side of the roadway on ramps, right? You do see them. So don't ever let your dog drink any of those water bottles because they're not water bottles anymore. They are urinals. So so keep that in mind, right? But thanks to those people because that is a very tough job. it's very hard for mostly the landscaping companies to get those guys and gals out on the road and to make sure they're there. And especially the manual people, right? So we got plow drivers, we got cat drivers, we got backloader drivers. But keep in mind, you also have those people who are actually shoveling this stuff on the walking paths and so forth. And that is brutally backbreaking work, right? Guys my age every year, unfortunately, have heart attacks and die doing exactly that, right? That is a danger zone, especially for men over a certain age, right? So we don't want to be doing our own shoveling if we can avoid it. Um, we plow and shovel, we don't remove. So most associations, a few remove snow, but most associations just plow and shovel, which is moving it out of the way. Oh, there's Ray Barton. Hey, Ray. Uh, we plow it, right, and we shovel it. We don't remove it. So there are some associations that are so tight space-wise that they actually have to remove snow, and they bring it off site or put it on a remote area of their site because the cart paths and the parking areas are so tight that they can't mound it up, right? They can't mound it up because it'll block the cart path. But keep in mind when you're speaking to your memberships and having membership meetings, that we don't remove snow. The snow 99% of the time stays on site. It doesn't go somewhere else. So it is hard, right? Because it sucks up space in parking lots. It sucks up space in visitor parking spots. It sucks up space in other areas. And people should have a level of understanding of that. You know, what ruined the entire world, right, is Disney World. We love Disney World. We love Disneyland, but we don't live in Disneyland and we don't live in Disney World. So it's not perfect. It's not going to be perfect all the time. You shouldn't expect perfect all the time, especially when you have a snow and ice storm that throws stuff at you and stays there for 2 weeks, right? So it has to be a cooperative effort, and I would continue to send that message out there to your residents. I know I'm preaching to the choir. I know it's easier said than done, but I think you should continue to try and preach a positive message, right? So we don't remove, though. Make sure people understand that we don't remove snow generally. What about the types of contracts for snow plowing and shoveling? So you generally have the three types: the per inch per storm, per inch per storm. You have what's called snow insurance, which I'm not a fan of. It has become very popular again recently. And then you have time and material, which is the most expensive type. But let's talk about per inch per storm. So per inch per storm is you just have a fee schedule that gets attached to the specifications and the contract that we write, and it just gives you per inch per storm. So 2 to 4 inches, 4 to 6 inches, 6 to 8 inches, etc. And sometimes if it gets over 12 inches or higher than that, you'll see an hourly rate. And then what you'll also see is unit costs for heavy duty equipment. So usually when you get over a certain inch, you'll see things like hourly rates for a backhoe operator and an operator themselves, right? So you'll see a fee schedule for that. Snow insurance, or it's not really snow insurance, but it's a contract that basically is a flat fee contract that says we will do all of your snow for an entire snow season, no matter how much or how little, for X dollars, right? They call it snow insurance because it's really a gamble by the contractor that they won't have any snow and that it will be a win, right? It'll be a win. And then there are some vendors who will do a snow insurance type of arrangement, but they'll even give a percentage back if it doesn't go over a certain number. I haven't had any problems with the so-called snow insurance this year yet. But if anyone remembers, I think it was 1996. In the mid to late 90s, the so-called snow insurance was very popular. And then we had a crazy snow year in, I think, 96 or 97. And what happened at that time was many vendors, and I'm sure they're not around anymore, but many vendors who had snow insurance deals did not show up at associations that I represented because they were out making money somewhere else. You see what I'm saying? Because they were the associations and the commercial properties and the shopping malls and all that stuff were desperate. They had already gotten some or all of their snow insurance money. and they just blew off their clients that were based on a flat fee and went and serviced the places that they could service on time and materials because so many clients were desperate for snow removal. So in that late 90s period, um, I didn't see snow insurance type contracts for a long time. And I haven't seen them a lot until probably the past 3 or 4 years. They seem to be coming back in vogue. Um, but we'll see. Like I said, I have not had those phone calls that I had in the late 90s where we had vendors just not showing up. But it was a major problem and resulted in a number of litigation cases in the late 90s. So you have to be careful with snow insurance type arrangements. I'm not saying it's all bad. It's not. Um, but you just have to be cautious and you have to make sure you're dealing with a reputable vendor who has been involved in a relationship with your community for a long time. Time and material is what it says it is, and it can be very expensive, right? Um, you're going to get what you pay for, essentially. You would hope, right, that they will be more than happy to dust off every parking spot, but you're going to pay for it, right? So time and material can be very, very expensive. Um, so that's the kind of relationship in a snow removal contract world. And then I go on to it's a relationship, and typically with a landscaping vendor. Why do we care if it's a relationship? Because you have to keep in mind that you can't throw out the baby with the bathwater. Even if you have a bad experience with one snow vendor or one snow event, usually it's a much longer term relationship, and it usually relates to your very, very, very significant expense line item, which is landscaping, right? So many landscapers view snow removal as sort of a necessary evil. That's not their primary business. That's not what they would love to be doing. Their real business is landscaping. They do it as an ancillary thing and try to make some bucks on the side. But you don't want to have a bad experience with a one-time bad experience with a landscaper and just go nuts and throw them off your site and end the relationship. So I counsel everyone that if you have a bad snow experience, to have a sit down with those vendors and try and get a handle on what happened, where it will change in the future. How can we change it in the future? Do you owe me some money? Do I owe you some money? How do we work this out and make it right? Right. So keep in mind that it's a relationship. What's the plan? Snow stakes, parking areas, cars. Where do we start? Who makes the call? So snow plans, right? People haven't thought about them for the past 3 or 4 years because it's been relatively easy, right? People are like, it's probably not going to snow anymore. New Jersey is the new North Carolina. Everyone's happy. It's a beautiful thing. And but that's just not the case, right? It's not North Carolina. It's not South Carolina. It's New Jersey still, right? No matter what anyone says. And it gets cold, and as we learned right now, it's been in the 20s now for what, 2, 3 weeks or so. So we should have a plan. We should have a plan, number one. And that plan, I like the idea of putting it on the website so that people understand what to expect. I like doing things like snow stakes. A lot of associations do not do snow stakes. I like snow stakes. They're those orange, like little rods that people put out around the Belgian block curbing and the funky parking areas, so that keep in mind you have a plow driver driving this big truck with a giant plow, usually in the middle of the night, often dark and snowy conditions, and if they can't see where the Belgian block line is, there's a good chance they're going to whack it and take out some of your Belgian block or damage your aprons and so forth. So you have a plan itself, and then I think it's money well spent if you pay to have snow stakes put out. And what about parking areas, right? Parking areas and cars. Where do we put the cars? Should we shift the cars? Do they go from what court to the other? What is the timing? Who's going to be involved in monitoring that? So that's a real challenge, especially in tight condo associations. It becomes almost impossible to effectively plow a parking lot unless you have the cooperation of the residents, because the space is just too tight. So that puts a real burden on the manager, and it puts a real burden on the board members if they're going to be helping direct snow removal, right? Not snow removal, but plowing, moving the snow around, because you do want to get parking areas cleared. those areas where you have like the parking stall and then you have that strip of snow and ice, right? That's an invitation. God bless personal injury attorneys, but that's an invitation if you leave all that stuff out there for people to step out of their car 2 days later on a slab of frozen something or other and break a hip, right? That's going to happen, right? So you want to make sure that you have a plan. What about the parking areas? Who's going to move the cars? Where are they going to be moved, etc. Where do we start? That sounds pretty funny. Where do we start? I don't know how many of you have this problem, but I have a number of associations where, the evil board members always have the plowing start in front of their house, right? And we know that's not true. We know that's not true, but they're the kind of things that get thrown at board members. And to do that and to anticipate that, I have a number of associations that rotate the starting point, right? They rotate the starting point to make the board members defensible so that the members don't get out there and they go, oh, it's always in front of Nick's house. You always start there. That's the problem. Hey, Nick, you know what I'm saying? So you want to at least make yourself defensible, because if in fact, for whatever reason, convenience or otherwise, that the plowing happens to start on a street or a courtyard or a cul-de-sac where a board member lives, God forbid, right? Because you will hear about it. Because as well as I do, it will turn into a giant conspiracy because that board member wants his house cleared out first, or her house cleared out first. Who makes the call? Who makes the call on snow call outs? So that's a contractual issue that you really have to talk about among the board members, the management representative, and the vendor themselves. So many boards are reluctant to put that on the vendor because they're like, oh, the vendor, he'll decide to come out or she'll decide to come out immediately, right? Even if we say don't, if it's all the call is on them, they will be inclined to do work and overwork the site and charge us too much. But the flip side of that is if the management representative or the board retains the power, the snow captain, if you will, to make the call on who comes out and when they come out and whether they put salt down or whether they don't put salt down, the vendor is probably going to have a discussion with us about limiting their indemnification provisions in the contract, right? Because they're not going to want to agree to indemnify, defend, and hold the association harmless for trip and falls and things like that if they don't have the power to decide when to come out and when to apply de-icing agents, right? So those two concepts are tied. Who makes the call? How much indemnification, defense, and hold harmless the association will get from your vendors, right? So you have to be careful about who makes the call. A lot of associations, we actually do have snow captains who do make the call, which is a tough job, and it keeps you up all night watching the weather and not sleeping. What standard are we using? So I won't get into it tonight, but there are various standards. There are various weather reporting channels. There are various weather stations throughout the state and country that are referenced in your contract, should be referenced in your contract or referenced in your specification, because based on the pricing of your contract, you may see a significant difference between, say, a 4-inch storm and something that falls above a 4-inch storm, right? And you need a standard reference so that you can refer to that when you're looking at charges after the fact. Does that make sense? You want an objective standard. You don't want the snow contractor going out there with a tape measure and saying, I stuck it in a drift in the parking lot and it was a 10-inch storm, right? And you don't want a board member saying, I stuck it in there where it all blew away and it was only a 2-inch storm, right? So you want an objective standard to refer to when we're talking about measurements on the per inch storm type of situation. Setting realistic expectations, communicating phone blast, email blast, text blast, and website blast. So again, I know that a lot of people weren't thinking about snow in the past 3 years, but communication is huge, right? Communication is huge, and we have so many tools at our disposal now that are actually redundant tools, right? The school systems are very good about this. When my kid's school is going to have a 90-minute delayed start or what have you, you have a phone blast, you have a text blast, you have an email. It's on their website. right? So it's pushing information, pushing information, pushing information. So the more you can push information, the better you'll be and the more defensible you will be after the fact. Keep in mind what many people are unreasonable, right? We know that. They're the people who you deal with all the time, right? That they're the people who call you at 6 o'clock in the morning after the 8-inch snowstorm last night and say, why is my walking path not cleared yet? And you know what? Everything goes through our heads as the lawyers and the board members, the managers. Where the heck are you going? Right? At 6 o'clock in the morning, right? And because most of the people will say, I'm not going anywhere, but I insist on my walk being plowed right now, right? And that just is not realistic. We'll talk about people who actually do need to be plowed out and what that has to be, how that has to be addressed. So setting realistic expectations, right? When will the vendors start removing snow or moving snow around? When will they expect it to be finished? What about salt treatments and de-icing agents, right? So you need to explain this as best you can. And again, websites, email blasts, etc., will be very helpful to your people for understanding. What about aging in place disabilities and reasonable accommodations, right? What about that? What is the biggest thing we hear about associations, especially age-restricted associations? We never did this for people before. We never did this for people before, and that's usually followed by, she's a faker, right? She's a fake. There's nothing wrong with her. Look at her. So the issue with, we never did this before is, generally speaking, in active adult communities, people age in place. They move in when they're 55 or 60 years old, and they stay there. And eventually, shockingly, they turn 60 and 70 and 80 and 90. And if they live long enough, God bless them, they're healthy over 100, right? But even though those people who have aged in place for the past 20 or 30 years are not what we would classically be called disabled, often they're less abled, right? Less abled. So what did I see this year? First thing I saw this year, and we resolved it right quick, was we had a woman who called the property manager and called the board president and said, their policy there, by the way, is we will shovel one shovel width from the walking path to the mailbox, right? One shovel width. Well, you know what didn't fit in that shovel width was the woman's walker. Her walker did not fit. The tennis balls, they go out, they get stuck in the snow, all those things, right? So she called, I need to get to my mailbox. It's urgently important. The wrong answer is, you don't need to get to your mailbox today, Mrs. Jones, right? She probably doesn't need to get to her mailbox today. But really, what is the real answer to that is, and the board president and the manager did the right thing. What do? You send the crew out there, make the stupid walk wider, right? Even though there were board members, I think, who were like, Fran, she doesn't need this. We don't know. This is going to set a precedent, right? We're going to be shoveling everyone's walk wider, God forbid. I can tell you, right, if you have a Fair Housing Act claim, that Fair Housing Act claim for a disability that you didn't accommodate would cost far more than sending a dude out there or a lady out there to widen their walking path a tiny bit, right? And that's what happened. The lady was happy. She got her mail, everyone went away. Again, even one board member was saying, Fran, let's just take the mail out of her mailbox and hand it to her. Don't even get involved in the debate. It wasn't even worth it, right? Not even worth it. De-icing agents and traction materials. So this is a cost-benefit analysis or risk-benefit analysis. There's no question that the freeze-thaw cycle will do some damage to paving, concrete, and so forth. Not all. A lot of the developer stuff chirping about de-icing agents is just that. It's an excuse for bad pours. It's an excuse for bad masonry work. It's an excuse for bad contractor work, poor performance, improper paving, and so forth. So don't buy into developers and subcontractors nonsense about, oh, the association went out there and used de-icing agent and ruined everything. And we told you to never, ever, ever use de-icing agents, and there you should have been bound for it. Because the answer to that to a developer is, and this is a wise guy answer, but okay, well, here's the deal. We won't use any de-icing agents if you indemnify, defend us, and hold us harmless for every slip and fall case we have on the site when we don't do these things, right? Because that's just craziness, right? You just can't not do that. What's the problem with things like traction materials? Why do associations generally use de-icing materials rather than traction materials? Traction materials generally are tramped all over the place, right? So that's things like cinders, sawdust, things like that don't go away. And they just, the reason many people don't use them is because they wind up, they're not as effective, generally speaking, and they also destroy people's homes. I'm not saying you can't use them, but that's a reason. I generally hear when people say, well, why don't you just use traction material like cinders or things like that? And it usually creates a crazy mess. So oftentimes people find that's not reasonable. Cleanups and callbacks. So cleanups and callbacks. I had one call this past snowstorm is, Fran, we had our contractor do the site. Site was good. He did a good job. And we're not calling anybody back. There's no need to call anyone back. Okay. What about the downspouts that are draining across your driveways and it's freezing? Okay, that's not our problem. Actually, it's your problem. It is your problem, at least in that association where they were common driveways. So just doing it once, we cleaned up the storm is not enough, as you all know. And again, I'm preaching to the choir. The association's board is required to take reasonable steps to properly maintain the association's common property, and even on the lots, to the extent the association has an obligation to maintain those areas, right? So you can't just do a one-shot snow removal and then turn a blind eye when you have a melt off and refreezing in areas that will cause slip and falls. Because again, personal injury attorneys, regardless of how much I love them, they really, really, really like snow. Right? They like snow and they like ice even better. And they don't want to see people get hurt, but I can tell you with certainty that the trip and fall and slip and fall cases come in after storms like this and after prolonged icing and melting and icing, right? So again, no disrespect to the personal injury attorneys. People who get hurt should be helped, but you don't want your people getting hurt. So don't shy away from the call out. Right? Even though your place looks pretty good, make sure somebody is checking out the site, make sure people are taking a look and applying additional de-icing agents or salt or what have you to make the place reasonably safe. Again, but we're not through transition, and the developer said, don't do anything. You can't rely on the developer at all in the reasonable care in terms of making the area reasonably safe for your residents. So again, don't buy into the developer speak when it comes to making your areas safe. Documenting vendor failure, ending the relationship, and securing the replacement. So even though I wrote that phrase that way, documenting vendor failure, ending the relationship, and securing the replacement, what is the first thing you do? The first thing you do is you secure a replacement, right? The first thing you do is want to secure a replacement, because in many markets, there are not replacement vendors available, period. Midstream, right? Mid-season, they're not going to sign you up. Some of the places that I have right now, some of them are switching vendors, but because they have a successor vendor. But you don't want to fire a snow removal vendor that you're not happy with, only to find that you can't get a substitute vendor and have to go groveling back to the vendor that you just fired, right? So you don't want to do that. You do have to document the vendor failure, though. So I have a very large community where the snow vendor performed very poorly. And when the property manager called me, I said, take a ride around and videotape as much as you can, giving examples, right? So you document the vendor failure. You may have to end the relationship. I don't know if this association is going to end the relationship or not. They're in the process of speaking with the vendor. But if you're going to end the relationship, make sure you have a successor vendor in your back pocket. Too many people get really enraged and they fire the vendor and they have nothing else. Post-clearing inspection, you got to check your site. So whether it's the property manager, whether it's a snow captain or a board liaison, check your site. Document damage. What are you talking about damage, Fran? Documenting the damage is usually you'll see smashed up Belgian blocks. Sometimes you'll see landscaping totally destroyed and crushed. Um, the thing with landscaping totally destroyed and crushed in a large storm, sometimes it's necessary. So a vendor may, and perhaps rightfully so, say, hey, board members, we had nowhere else to put this snow. We had to. We had no choice, right? So yeah, we killed some shrubs, and that should not, in my opinion, end your relationship with a snow vendor, right? Because they have no choice. The snow has to go somewhere. But damage can be damage to your curbing, damage to your driveways, damage to your aprons of driveways. Uh, what else? Street lights, right? Street poles, things like that. We see damage there. Damage to people's vehicles on the site, where you might have an indemnification defense and hold harmless claim. A tougher one to prove, but I have seen some associations pursue it. I'm not a huge fan of pursuing it, but salt usage that kills vegetations along walkways, right? So there are some associations who try to pursue that claim because they say, Fran, they oversalted, they overshot the salt spreader, and it went on our vegetation and it killed it. You know, is that just an ancillary part of doing the job? It's kind of inherent in the risk of the job. I'm not sure. I guess in the right case, maybe we would sue upon it and pursue it. It's just, again, that's a relationship thing with your snow vendor. So post-clearing inspection, you got to document the damage. You got to preserve the evidence. So preserve the evidence, notify the vendor as soon as possible, submit the claim, and set off on the payments, right? So if you owe a snow vendor $100,000 and you have documented damage of Belgian block curbing that has to be replaced to the tune of $10,000, you're going to pay $90,000, generally speaking, right? That's a set-off claim. And then you want to provide the documentation to the vendor about why the claim is $10,000. And some vendors will prefer to have one of their subcontractors do the replacement. Sometimes they can get it more cheaply. It's really up to you in terms of deciding who's going to do the repairs. So you preserve the evidence, you notify the vendors, you set off if you have to. So here's the big but, right? But what do we do in terms of paying for this thing? How do we pay for this? It blew our budget away. What about this? It's a whole mess. The snow was one big mess, but now the money is a much bigger mess. Some associations have a snow fund. They actually set aside a line item in their budget year after year. It's almost like an operating fund / reserve that will cover excessive snow expenses. Not a bad thing. Budget increase. So you can, if you have a shortfall in terms of snow removal, you can increase your budget. Most associations can increase the budget mid-year. Not all, but many associations can. Associations often don't like to do that because it artificially increases your monthly assessment when it is directly related to snow. Cannibalize reserve funds? I would have to say no, 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 no under the new law, right? Under the new law, you're mandated for having appropriate funding of your reserve fund and your reserve budget. So I would not cannibalize reserve funds. I can't advise you to do that. What about special assessment? There are evil words. People hate to hear the word special assessment, but I go with a yes, yes, yes on this one. Why? Why is the special assessment really, I think, the appropriate way of dealing with a snow overage? And you would do a special assessment typically at the end of the snow season so that you know when you have wrapped up your snow expense, because it is almost impossible to go to the special assessment well twice or 3 times or 4 times, right? You don't want to do that because people will go nuts. Why is the special assessment more reflective of reality? So your regular monthly fees, including your budget for reserve, which should reflect the, we'll say, total cost of ownership, has a snow line item in there, which should be a reasonable snow expense based on experience. But if you pop that budget a special assessment for snow, number one, will be very relatable to your people, right? So they'll be like, hey, we know the assessment is relating just to the snow overage, and it's not going to artificially inflate our monthly fee going forward for the rest of our lives. You see what I'm saying? So you don't lock into an increased fee that many associations are reluctant to back off of once they've gone to an increased fee. That makes sense, right? And you would want, if you're going to go the special assessment route, you want to do it as soon as possible after the snow season has ended, because if you try to pass a snow assessment in July, people are going to be really angry because they have very short memories, and they're going to be like, we don't remember any snow expense. What are you talking about? But if you do it in March, people are going to relate to it, very, very much in a better way, because they remember sitting in their fleece for 2 weeks. They remember sitting in the ice for 2 or 3 weeks, right? So they will be more supportive of a special assessment, and you can articulate to them why we're doing a special assessment rather than increasing the budget, right? And many, not all, but many people can relate to that much better once it's explained to them. Send the delinquent accounts to the attorney for collection ASAP, right? So as you know, I do a lot of collection work, a lot of collection of assessments. Many associations sit on their collection late payers too long, right? So in most of my associations, it's management late letter, lawyer letter, right? So it's 1 month, 2 month, 3 months. So usually it hits my desk, usually within 90 days, ideally within 180 days. And then the collection letter goes out, and it's much easier to get people to pay when there's a very low balance than there is when the first letter I'm sending out says $2,500, right? So to keep your cash flow moving, you want to send non-payers out for collections as soon as possible, right? Because it becomes a cash flow issue. What is ice damming anyway? I just put that in there as a little note. So ice damming is generally when, and Mitch Frumpkin and Dan Rush and all the fancy engineers in the industry can speak to that much better. But it's generally when your attic gets really, really warm, and then you have a freeze-thaw cycle up on your roof, and it blocks the drip edge and the gutters of your roof line, and the ice backs up usually up under the ice shield and under the shingles, and it actually saturates your roof and puts water into your building, right? So that's something to think about. Like I said, Mitch Frumpkin is well known for dealing with ice damming. Dan Rush, all the engineers in the industry, Steve Morris, all those guys and ladies know ice damming. So if you see that happening out on your site, you see it in condominium associations. You can see it from the ground backing up under the shingles. Speak to your association engineer and say, hey, do we need to do something now in this storm to prevent leaks? And going forward, do we have to address roofing ventilation, right? The various ventilation in your roof. And God forbid, and we see this pretty regularly, bathroom vents and other vents that vent into your attic space rather than venting through the roof. And what's happening is you're just pumping moisture into your attic space. So anyway, if you see that, especially from the ground, make sure you speak to your engineer about dealing with that. Injuries and insurance, I preach this all the time. If you have an injury, if you have somebody gets hurt on your property, please report it to your carrier, put them on notice, make sure people are aware. Oftentimes people will get seriously injured and they will say, don't worry about it. I'm not going to report it. I'm not the type of person who would ever have a claim or submit a claim. And that's easy to say, but as you know, a year and 364 days later, the complaint is served on the board president or the property manager, and everyone's unhappy, and the insurance company hasn't been notified, and they may deny coverage. So you got to be careful about that. So that was kind of a blitz for 45 minutes there. We do have, I think, some questions. I had one pre-question It was sent in by Kelly Spencer. She's a property manager over at Sage One Property Management over in Allenhurst. They've been around quite a long time. And she says, we have a resident on one of her properties that wants to shovel his own snow and have others do it as well to save costs within the association. No, oh my God, no, please don't do that. Right. And she was, Kelly is totally against that as well, I believe. But I think she just wanted to highlight that issue for everyone who's on with us today, because although it's well intended, right? Although I'm sure that fella has a good heart and he's trying to save the association money. We don't want him to have a heart attack, number one. We don't want him to get hurt, number two. And we don't know what kind of job he does, and we know he probably doesn't have insurance for his snow shoveling operation, right? So we want in an associations in a business, we want to handle it in a professional way. We want to handle it with vendors who are insured and properly trained, and people who have workers' comp insurance, so that God forbid a worker gets hurt on site. We don't want a DIY association. The most dramatic example of this is I had an active adult community where the building and grounds committee wanted to take out their chainsaws and trim all the trees throughout the community. And the last thing I wanted was a bunch of elderly men running around with long chainsaws limbing trees, right? So I freaked out, and the manager freaked out, and we stopped that. And those gentlemen were very angry with us because of the association, the amount of money those men would have saved the association. Instead, they went out and did the right thing and hired an arborist to address the trees, which was the right thing. And nobody cut off their fingers or arms or fell off a ladder, which was really good. So we don't want DIY associations. Here's a note from Barbara. Several surrounding communities have stopped shoveling sidewalks and walkways. They are only doing roads and driveways. We have debated for several years. I'm wondering how many other communities have stopped. So Barbara, I've heard that recently too. The question, the starting point, I think, in that analysis is, where does your duty arise? So many governing documents say you must do the walks and you must do the walkways. So if you have a duty, right, you must perform it, right? You must perform it with reasonable care, right? Because everyone, you've heard me say this many times. What does a personal injury attorney have to show in terms of liability? Duty, right? Duty, breach, causation, and damage. Duty, breach, causation, and damage. If you can't prove any of those things, you're gonna have a problem proving your case, right? Duty, Fran McGovern had an obligation to clear the snow away. Breach, he didn't do it. Causation, I slipped on the area that Fran was supposed to have shoveled. That's causation. So even if you have duty and breach, if there's no link between the breach and the damage, then the case would still fail, right? So somebody can be negligent, but if there's no actual causation, so I have a duty to do my parking lot, I don't do my parking lot, and somebody slips, but he slips out in the public street in front of my parking lot, there's no causation between my negligence and his damage, right? So he has duty, breach, and damage, but no causation. So causation is the link between the negligent act and the actual damage, and then damage, right? So if you have duty, you have breach, you have, hey, causation. The guy fell down, but he has no damage. He wasn't hurt. He was young and strong and bounced right back up, right? Then there's no liability, right? If you don't have damage, there's no liability. So duty, breach, causation, and damage. So on the walkways, if you have a duty, it's usually in the governing documents. And if you don't want that duty anymore, you should amend your governing documents and remove it. The rub there is, and this, I have a project going on right now with this, is many municipalities have ordinances on the books that require clearing of the sidewalks, right? Right now, someone is challenging, hey, Fran, we want to challenge the municipality's imposition of that upon us. Can they do that on private property? I think the answer is probably yes. But I haven't done the research yet, so I don't want anyone to quote me on that. Um, but it's not just taking that duty out of your governing documents. You have to see what the municipality requires, and again, put the governing documents aside, um, where there may be a duty as a matter of law. There may be a duty as a matter of law. Where do we see that? Generally, there's a case out of Hoboken where they had a residential condo association, and on the first floor there was commercial, right? So it was like street level commercial, and there's slip and fall case on ice because they said the association did not properly shovel the area, and it was commercial use area because it was retail at the street level. Um, Surprisingly, this was very surprising to me, but the plaintiffs lost because the court said that the areas were in large part, in overwhelming part, residential in nature, and they weren't going to impose a duty upon the association to clear those areas as a matter of law. So there is the governing documents, there's municipal code, there's ordinances, but then there's also a case law and common law that applies to snow clearing too, that may impose a duty or may help you out of a duty. Barbara had an actual question, and I see she has a hand up. You got it.
Yes, what I was saying is the problem that we're finding, which is why these others had it. Yes, the governing documents say something about sidewalks and walkways, so we would like to change them because we're finding we spend the time and money to have them shoveled.
Yep.
Then they thaw,
Right.
or snow blows. Now they freeze over. They're even more dangerous than they were before. So we're having to come back and do a second and a third round,
Yes.
which is bringing the expenses even higher. So we're starting to say, if we didn't do them at all and your driveway is done, you can get down your driveway, the roads are done.
Yep. So I think you'd have to handle it case by case. So I would have, if any association is going to walk away from or try to walk away from the duty to do sidewalks, walkways, things like that, case by case with your attorneys, right? If you're one of our clients, we have to sit down and see exactly what's going on. We have to do a little research on the municipal requirements and case law on that, because sidewalk liability in particular is very dicey before the New Jersey courts. As I said, the Hoboken case is a good example of that. If you had asked me before that case went to trial, I would have said that the court was going to consider the first floor area commercial space, and I'm going to impose liability on the association, and it did not. So it's very odd. There's a case out of Plainsboro too, where the association attempted to escape liability for the private sidewalks and was not able to. They were found liable. So it's very case by case. It's very fact sensitive. So Barbara, you're right. The expense and doing it seems ludicrous, right? It's just like taking, again, it's almost like litigation. You're taking piles of money and setting it on fire, and nobody's even using the stupid sidewalks, right? Nobody's even, it's the most, it seems like the most wasteful use of money, right? So I think it's worth exploring. I'll give you the example, the most dramatic example I have had in my career. So we had, we only represent associations, and we only represent associations in New Jersey now. At one time, we also represented associations in the 5 counties around Philadelphia, Delaware, Bucks, Montgomery, etc., Chester. I had an association there that was going through transition. It was an active adult community, and they had a lot of sidewalk defects. And there was a gentleman who was the board president at the time, and we had not done a transition settlement agreement with the developer yet. Excuse me. The board president raised the exact comments that Barbara just raised. And this was shocking to me. And I at first said, no way. And they voted to do it. The transition settlement agreement provided for, instead of the developer fixing the bad concrete on the sidewalks, removing all of the sidewalks from the community. Insane, right? Insane. We had to go back to the township and get a site plan amendment to remove the sidewalks. And the association membership voted, and they did it. mean, to me, that was incredibly insane, but they did it. And the developer, rather than fixing the flat work, did it. And the board president's point at the time was, Fran, the people who live here don't even use the stupid sidewalks anyway, right? And now, again, I disagreed with the board president, but that was the will of the membership at the time, and that's how they settled the transition. And the budget for removing snow from the sidewalks went away because there were no sidewalks to shovel. So that's my craziest example there. Maddie says we have a plan about who gets plowed first for each new snow event. Yes. So who gets plowed first each time for each snow event is really important. That's really great that you do that. And I didn't mention this before with disabilities when I was talking about my friend with the walker. The other disabilities, people who need to get out, where do we see that? Dialysis patients, right? We see dialysis patients all the time that need to get out because if you have dialysis, say 3 days a week, and you miss a dialysis treatment, you may die, right? That's very important for any of you who have, bad problems with your kidneys and things like that. So dialysis patients really need access, right? They have to show up at the unit. They need to sit in that chair. They need to be plugged in, and they need to have their blood cleaned. So that's really important. And again, it's shocking to me today, but there are people who still who are on boards or committees who are not receptive to that. But you really have to be. And where else do we see it? We also see it with chemo patients. I don't see it as stridently with chemo patients, right? Because, and I don't know enough about chemo treatments. The older we get, right, we all know friends, and many of us have also had issues with cancer and cancer treatment, unfortunately. But I don't know enough. So I've been in meetings where people were debating who gets plowed out first, the chemo patients or the dialysis patients. And that's ludicrous, right? So you don't want to get in that debate. I generally recommend that the association work with anyone who has a disability, especially relating to short timeframes like dialysis, like chemotherapy, to make reasonable accommodations for those people, and have a list, right? So there's, some people call it the snow priority list, and the other thing to keep in mind about a snow priority list is if you have a snow priority list, what do you have to do? You have to do it, right? So there are some people who take everyone's names and they're like, hey, Joe, you'll get plowed out first. We know you have dialysis, but then they don't do it. And then if Joe has a problem, you're going to have a real problem, right? I mean, talk about liability. So anyway, the snow priority list, Madeline is correct. Most associations do have a priority list like that, especially for people with disabilities and who require treatment on a regular basis. But even like I said, with people where you don't have disabilities, you should rotate, especially the starting point, because from a political standpoint, that'll help you. Yeah, Barbara says, great, we rotate streets. We have several crews out at the same time. That's great. Maddie says WeatherWorks. That's one of the standards for measuring the per inches. That's an objective standard. You can use that as an objective standard. Barbara says DTE. Okay. Is that for what? The gripping stuff? Is that what you're talking about there?
No, when she said WeatherWorks, I thought she was asking who we use.
Oh, I gotcha. Yeah. Okay.
Yeah,
You use that as
we
your
use
objective.
DTE, but we go by the Monroe weather
Yes.
station.
Right. So you use that as your objective standard.
Right.
Okay, that makes sense. I was starting to think that you were using that as a traction agent, whatever they
No,
call
no,
it.
no traction agents. It's
Okay,
that met.
I forget what they call it, bituminous earth or something. You use it in pool filters too. Okay, all right, thank you. That's good. What if it's not common property? Beth Duffy, I see you out there, Beth. So Beth says, what if it's not common property? So the issue is, if it's not common property, do you have a duty, right? So many documents, especially in adult communities, say even if it's on the lot, the association shall plow or shovel the driveway, as well as the walkway to the front door and the front stoop, etc., and even the sidewalk if it's on the owner's lots. So the question there is, do you have a duty? This goes back to Barbara's question. So that's a good question, Beth. And I just had that at a large adult community in Brick, where for a long time under prior council, I think the impression was that the sidewalks were on people's lots. Therefore, the um, the association did not have a duty to shovel the walks. Excuse me. Um, and I think for a while there they weren't doing it. When we were brought in, we actually looked at the lot surveys, and even though they thought the sidewalks were on the lots, they were not. They were actually in a common area. The lots ended prior to the sidewalks. So again, that can be a very fact-sensitive analysis. But if you have the duty, you must do the duty. Terry, what about making ice melt available to residents for spot treatments days after the storm? So, you know, so in our office, so I own my office building. Well, I don't own my office building. The mortgage company owns the office building, but I get to pay them. So I get to run the office building. And we do leave buckets out there of they're kitty litter buckets, but they usually contain a salt mixture in them. I don't know from a personal injury standpoint how that would play out. We leave them there, and I personally regularly, if I see a spot in the parking lot when I'm going out at night or coming back in the morning, I will throw salt down. That's not going to be a substitute, though, for doing your professional duty and having follow-up inspections and having call-outs. So the problem with leaving the bucket of ice melt out there is it shouldn't lull you into complacency, right? It shouldn't be like, don't worry about it. We left some buckets of salt out there. Because most times, and I see this in my own office building, most times the other people who work here do not touch that salt bucket. They don't even touch it. I think I'm the only guy because I'm the guy ultimately, or not me, but the company has the duty, right, and has the liability if someone gets hurt. So I don't think it's a bad idea. Just don't rely on it. Can we really prevent all the ice in an association, even after we have spread salt down several times, especially after, as you had mentioned, the melting and refreezing? So Nick makes a good point. This is the Disney problem. There's no such thing as perfect in the real world. So you could, I mean, my parking lot right now looks like the salt flats, that they set the speed records on out there with those race cars. I got so much salt on my parking lot, and still, I'm sure if I walked out there right now, there would be a melted area with a frozen area next to it. Um, you, what the law says is you must act reasonably. But the fact of the matter is, even if you act reasonably, have call outs and put salt down, like Nick says, and someone slips and falls, it's going to hit your policy, right? And if people are injured, you can be sure that you're going to have a payout, right? Because that's just the way the world works. And that's certainly the way the world works in New Jersey. Juries and courts look at insurance as a way of spreading the risk and making people whole. Spreading the risk and making people whole, right? You generally don't want somebody who's hurt badly and injured and have no opportunity to get that addressed somehow, right? So rather than looking at it as you did a bad thing, it's punishing you. It's you can think of insurance as risk spreading. The flip side of that, right, is the immunity statute. How many of us have the immunity statute in our governing documents? Right? So lots have the immunity statute. So what the immunity statute says, if you amend your governing documents, that if you have the immunity statute in your bylaws, a unit owner is prohibited from suing the association for bodily injury resulting from negligence. That will save you loss run on your insurance premiums, right? So a plaintiff who is a unit owner would have to prove what? Gross negligence or wrongful purposeful act. So gross negligence is you're aware of the risk and you blow it off. That's what concerns me about Barbara's question. Even if you had the immunity provision in your governing documents, if the association was aware of a duty, say, for example, to clear the sidewalks, and they said, you know what, that's annoying to us, it's expensive, we're blowing it off. even if you had the immunity language, it's very likely that a personal injury attorney would get past the immunity statute because they would say you knew of the hazard, you knew of the risk, and you blew it off anyway. So many associations, especially active adult communities, amend their bylaws to include the immunity provision. Why? Not just because of snow and ice, because the older we get, the more we fall down, right? The older we get, the more we fall down. Old people fall down. I'm sorry. I'm not as good as on the feet that I was 20 years ago, right? None of us are, right? People stumble, people fall, they don't catch themselves. And what else? Very few older people like us can stick the landing when we do fall, right? Older people break when they fall, right? It's not the flying that hurts you, it's the landing, right? So people who are older who fall, they break their wrists, right? They break their wrists. What do? They break their hips, they break their knees, right? All those things. So the immunity statute can really help with your loss run because people do stumble and fall, even if you don't have displaced concrete slabs, vertically displaced concrete slabs. You do the best you can. You inspect your sidewalks regularly, and there are no trip hazards. People will fall. They will get hurt. In the adult community, they often get hurt seriously. And sometimes, unfortunately, we've had cases where people have died because if you fall and hit your head, especially an elderly person, you may not work out so well. You might wind up with, God forbid, a brain bleed, and it could end things for you. So which can be a potential very, very, very serious claim in terms of recovery. So we want to make things reasonably safe, primarily because we don't want people to get hurt. Secondarily, because we want the association to be protected from financial catastrophe, right? We don't want huge financial losses. So they are some of the tools that you can kind of try to insulate yourself. Number one, do the right thing. Number two, think about amending your governing documents. And number three, making sure you have proper insurance. Anna says, hey, check your municipalities. East Windsor just adopted an ordinance about privately owned salt storage. Our ordinance sets time frame and methods for storage. The main goal is to keep de-icing materials out of the storm drains. Citation to East Windsor Ordinance number 2025-2. So Anna raises a really important point that I have talked about for a while now, and it's largely ignored. And that is salt storage, right? So when we were talking about salt storage before, it wasn't the kitty litter bucket outside the door of the entryway. And it's really an issue that comes down to many snow removal vendors will say, can I store salt materials on site? So many of us will drive through, especially active adult communities, they'll see a back parking lot area with a huge amount of salt on it, right? And putting aside the East Windsor ordinance, which I think it's probably a good ordinance, that salt, as it's raining and snowing and melting and freezing, is just draining into the waterways, right? And people forget that these waterways and storm sewers drain right to streams and ponds, and they kill fish, they kills plant life, etc. So Anna raises a good point. When you're looking at your contractors' provisions and proposals that say, we want to store equipment and materials on site, how are you going to do that, right? Is it going to be are you dropping a storage container where the stuff's going to be kept dry? Or are you thinking about amount of salt in the back parking lot, which is not such a good idea? And we try to include in all of our contracts that the vendor will be liable for any and all claims relating to environmental damage. The issue with environmental damage is, even if you put liability on a vendor, typically the law says the property owner is still stuck with liability. So the problem there is, if you put it on the vendor and the vendor packs up his truck and goes home and doesn't have insurance, you're going to get zapped with it anyway, right? From the environmental standpoint. Many environmental laws say it doesn't matter who you get identification from, you're still liable. How do we handle residents who don't clean or remove snow from their cars? We don't have assigned parking, As their cars defrost during the day, it creates runoff and freezes. If someone slips and falls on the ice and sues, can we sue the person who owns the car that wasn't moved? So first of all, that's a good question, Dawn. You should have a rule and regulation on your book that you must clean all cars before a certain period, number one, and you'd have to coordinate with your snow captain or your vendor. Number two, if they don't clear it, you may want, and I haven't seen this, but you may want to put in your quote that if it's not cleared by a certain point, the vendor will clear it at a per charge fee, and it will be charged back to the owner of the car. That raises a real knotty management issue because do you know the ownership of the car? Are your cars registered? How will you trace it back? Can we charge the whatever $50 or 25 or $30, whatever it is, to clear off the car back to the unit owner's account? So I think the issue there is documentation and education. But if you can clear it back, I think it's a good idea. I'm sorry, charge it back. I think it's a good idea. The question is, do you have authority to do that? And if not, can you put the authority in your docs? Can you borrow from reserve and pay it back? Terry, you're killing me. Can you borrow from reserves and pay it back? Not in New Jersey, I would say. So associations in New Jersey, the legislation basically, in my opinion, says no. This is where I think the legislation has gone too far. But like I said, the legislation has very good intention in terms of total cost of ownership and disclosure and transparency. But from a real world standpoint, when it comes to things like snow overruns, litigation cost overruns, because everyone, it's very important to get your lawyers paid as well as your snow vendors. I like to see associations being able to borrow from the reserve funds, but in New Jersey, I would say the answer would be no. In PA, Terry, I haven't practiced in PA in quite some time, so I wouldn't want to be quoted on that. Wayne says, as the son of a firefighter, I am particularly sensitive to having the plan include clearing around fire hydrants done immediately after the roadways, even before driveways and walkways. The firefighters and clearing the fire hydrants and fire suppression equipment makes sense to me, Wayne. I don't know if I see that in most proposals, but it seems like a good proposal to me. As is, I think those markers that are put on top of fire hydrants. Mike Polito says for privately owned streets, make sure you have a municipal services agreement with your township for some reimbursement to cover the snow removal based on township requirements versus your association requirements. So Mike raises a good point. You do get a small fraction of your snow removal expenses reimbursed through your municipal services agreement in your municipality. Some municipal governments would prefer to actually do the snow plowing of the streets. So I'm seeing that more commonly these days. Most municipalities historically have not been interested in doing that, but it is becoming somewhat more common. I don't know why. Maybe they just see it's cheaper and they don't have to deal with the association's lawyers and the hassle of it. But you should have municipal services agreement. Vicky says to cover snow removal costs, is it an option to not fund the reserve account? This is the reverse of Terry's question. Not fund the reserve account for the month or two to pay for the snow invoices. If so, would this be considered borrowing from the reserve fund? It's not actually borrowing from the reserve fund, but I think it would still be a violation under not funding the reserve fund because those funds are supposed to be earmarked solely for the things in the reserve budget. Kelly says, thanks, Fran. I'm glad, Kelly. I hope nobody is out there shoveling their walks themselves. Barbara says, we have residents who don't want the vendor to do their driveway. We have said no. However, is there any form that they can sign that takes any responsibility of the association? Away off from the association. So you can, right? So we discourage this, but we do agreements with homeowners to indemnify, defend, and hold harmless the association. We generally don't see it with snow removal, but we see it with putting de-icing agents on. So we have one association, I think they have fancy pavers and brick designs and stuff in their driveways. They will have the association plow them, but they don't want the association putting salt and de-icing agents on their driveways. the association will forbear from putting melting agents on there if they sign agreements to indemnify, defend, and hold harmless the association and put the association on their homeowners insurance. I still don't like it. I think if you bought into association, the association's duty is to maintain your driveway and your walkway. The association should do it. In this freeze and thaw cycle, we shovel, but then it melts and freezes over again. That's true. Now it's icy and even more dangerous. So we have to treat the sidewalks and walkways again. That's true. This raises our cost significantly. That's why other communities are stopping. I agree with you, Barb, that the associations find that it makes no sense. It's just a matter of you have to get rid of the duty if you're not going to perform the duty. Otherwise, you're going to be liable for breach. Tara says, but if the sidewalks and stoops are included in your master deed as common elements, would you not need to change the master deed to put those sidewalks and stoops back on the homeowner's property so the HOA is no longer liable? Yes, Tara, if you have the duty is yours until you remove the duty. You're right. So that's, Tara highlights that again. That's really important. Charlie says we give our vendor a list of medical issues for its cleanouts. That's great. Priority list. We have priority forms for chemo, dialysis, and first responders. I like that, Barbara. So Barbara also has first responder cleanouts to get prioritized because regardless of the snow, if they're first responders, they have to get out. When you work in an older 55 plus community, 25% of the population has a mandatory reason to get out immediately. Yeah, Beth Duffy says that, right? So Beth Duffy, I think, is highlighting an issue that does happen in older age restricted communities. It becomes a competition between who is more disabled. And that's scary and sometimes disingenuous. That's happened to me at a place in Ewing. I may have said this to you guys before. We got to the point that there were so many people who wanted handicap parking spots that we couldn't even have enough close to the building. So my recommendation, this is crazy, was to have valet service for several hours of the day so that at least certain people could get out and go shopping, because we just didn't have enough room for the amount of disabled people. They were really disabled people, but we didn't have enough room to people to be close enough to the doorway. So it was tough. We're almost there. This will be 225 homes in my community. That would be insane to prioritize. Yeah, Beth says, you can't prioritize everybody. We also have priority for people who have caregivers coming in. Yeah, that's an interesting thing, Kathy. I haven't seen that before, but Kathy says, they prioritize people who have caregivers. So imagine you're bedridden and you have a caregiver. You're not someone who needs to get out, but to live, you need someone to come in, right? So there are people, and I know dialysis is one of them. There are people who get their dialysis at home. They have in-house care, they have in-house feeding, they have in-house bathing. They are, just shy of a nursing home situation, and they need somebody there for a certain amount of time per day to keep them alive. So that's a really good point, Kathy. Now, I've never run into that in terms of snow clearing, but I really like it. I'm going to steal it from you. We had, let's see, we had a list of healthcare workers, docs, nurses, etc., right, who also needed to be plowed out. That's good. In a co-op, all sidewalks, paths, and driveways belong to the co-op. Are any of these the residents' responsibility? So Will Ferguson says, what about in a co-op? My experience with a co-op is that the association, not the association, we would call it the corporation is responsible. Terry says, wrap it up, Fran. It's Friday night. Go home. Thank you, Terry. Barbara says, thanks for your advice and knowledge. Bill says the same thing. Thank you. Maria says, thanks. Good to see you. I didn't see you, Maria, but thank you. So yeah, thanks, everyone. It's great to see you. I hope I didn't go on too long and bore you too long, but let's pray for a little sunshine and warmth and a little break in the weather. So have a great weekend, and I will see you next month. Take care. Bye-bye.